Good afternoon, students. So, in today's class, we'll be discussing the topic which is the preamble of the Indian Constitution. So, we will be looking into the features of the preamble, how this preamble or the historical development related to preamble has taken place in India through various landmark judgments through which the jurisprudence related to preamble has evolved in India, the features of it, the significance of it, and the latest development related to preamble in India. But before this, what we need to understand is that the preamble is the foundational principle. The preamble is the foundational principle of India's constitutional democratic setup. So, through a constitution, what we want to achieve in India is the purpose of preamble. So, this is the datum of preamble, the basis of having a preamble. Okay. So, now we will be moving forward with what is preamble, the definition of preamble. So, if someone asks, what is preamble? So there are different scholars who have given different definition to preamble. Some scholars like Palkhiwala has described it as identity card of the constitution. So in the same manner as we introduce a person, so we have an identity card, we ascribe some adjectives to that person, that this person is of so and so caliber, this person has so and so features, or this person has so and so qualifications, right? So in the same manner, we describe Indian Constitution through preamble. So that is why it has been termed as identity of Indian Constitution. The identity will communicate this to the world that Indian Constitution aims to achieve so and so qualities in the constitutional democracy of India. Some scholars like K.M. Munshi has described it as political horoscope. So why political horoscope? Again, the same thing. At the time of adopting the constitution, what was going on in the minds of the constitutional framers, that they aimed to achieve a constitutional setup in India of so and so features, right? So the future India, so the picture of future India was in their mind, that there will be or will achieve an Indian democratic setup in which people will have these political rights, social rights, economic rights, and there will be so and so institutions, right? So this all can be termed as future India. So that is why it has been termed as political horoscope. So the political future of India is described, or is the glimpse of that is given through preamble, right? So now let's come to the definition of preamble. So preamble serves as introductory statement. So similar to when we introduce any person, we say that so and so person has achieved these things in life, or is having so and so accolades to him. So in the same manner, the preamble provides an introduction to the Indian Constitution, right? We'll look into the preamble that India is a socialist, secular, democratic republic. So this is what? This is defining the features of Indian democratic setup. So that is why it has been termed as introductory statement to the Constitution. Then it articulates fundamental purpose. What is the purpose of having Constitution? So this is similar to having a preface in every book, that this preface provides you a glimpse of what the book will be containing of, what a message the author wants to communicate through the different stories which are there in the book. So similarly here, the fundamental purpose of the Constitution is described, or is the glimpse of that is given through preamble. So underlying philosophy, we will see liberty, equality, fraternity, having justice of social, economic, and political nature. So these all philosophy and guiding principles. Democratic republic, right? Republic we will be having a elected head. Democratic, everyone will have equal franchisee rights, right? So these all things are given by preamble at the very beginning of the Constitution. So that is why introductory statement. Now with this, we need to look at the purpose. Other than this, the purpose is core declaration. What is core declaration? Whenever we have, let's say, the preface or any identity card, this identity card, this preface is basically a message to the outer world. But here it is a message to the outer world as well as to the people of India. That the India which we want to develop will be a sovereign, socialist, secular, democratic republic, guaranteeing justice, liberty, equality, and fraternity to all citizens without discrimination. So this is a declaration made towards the outer world as well as a promise to the people of India, to the citizens of India, that we want to develop, we want to make an India which will be sovereign, the qualities basically sovereign, socialist, secular, democratic republic, and there will be justice, liberty, equality, and fraternity to all the citizens, right? So this is the definition of preamble and the purpose and the core declaration. So that is why we have already seen that some distinguished jurists have defined preamble as identity card and political horoscope. Now, after this, we will look into the historical development, how this preamble came into existence. So there must be some starting point to which we can trace the development of preamble. So that particular point in the history was Jawaharlal Nehru's objective resolution, which was brought into the Constituent Assembly on December 13th, 1946. So he basically read out this objective resolution in the Constitutional Assembly on 13th December 1946, which basically laid the foundational framework of preamble. At that time, there was not this design in the mind of the constitutional framers that we will be having a certain set of document which will be called a preamble, but this was aimed towards forming the philosophical basis of the constitution. Then later on, when the constitution was drafted and the constitutional was laid before the Constituent Assembly to be adopted, so on 26 November 1949, the date of the adoption of constitution, along with the constitution, the preamble was also adopted. That okay, we need to have a preface to the constitution, which will be basically serving the purpose of clearing the purpose and the core declaration towards the outer world and the citizens, that what all things we want to achieve through this constitution, right? So this is how the constitutional this preamble was adopted. Then on 26 January 1950, constitution came into force, and along with the constitution, preamble also came into force. So preamble as its guiding beacon. So along with the constitution, this came into force. Then there was an amendment in 1976, right? So this 42nd amendment, which is also sometimes called mini constitution. Why? Because some major changes were brought into the constitution through this 42nd amendment 1976. And in the preamble, two words, socialist and secular, these two words were added through 42nd constitutional amendment in the preamble, right? So this is how the journey of preamble has taken place in India. 13 December 1946, objective resolution read by Jawaharlal Nehru in the Constituent Assembly. 26 November 1949, adoption of constitution and the preamble. 26 January 1950, it came into force. And then 1976 amendment, that is 42nd amendment, two words, socialist and secular, they were added to the preamble. So next we will be moving forward with key features of the preamble. So we have discussed the definition, the purpose, how it has evolved into India, and now we'll be looking into the features. So what are the features? There is a preamble, it must be communicating something. So what it is communicating, that we are discussing in the key features. So first feature which is there in the preamble is India is a sovereign state. So what does it mean by sovereign state? That we will be an independent country, will not be having an interference of any foreign or any other domination, right? So we will be sovereign in our internal as well as external affairs. We will be the sole decision maker related to our internal or external matters. So India is a sovereign country. This is the first thing, first declaration made by the preamble. Then socialist. What is socialist? Again, here the socialist means the welfare state. Okay, one thing which we know about socialism is socialism, capitalism, communism. So these are ideology. Okay, our freedom fighters were heavily inspired by socialism because we faced the wrath of not just India, but the world faced the wrath of capitalism in the form of fascism, and World War II. So that is why we were heavily inspired by socialism. But what particularly about socialism we were inspired? Welfare state, which reduces socio-economic inequalities. So these things basically inspired us, preventing exploitation of the weaker section of the society by the well-off people, right? So this is why the preamble has the keyword socialist, sovereign socialist, right? This was an amendment, later addition by 42nd Amendment, but the purpose which it wants to communicate is that India, or the constitutional setup of India, will be such that it will be oriented towards establishing a welfare state free of socio-economic inequalities as well as free of exploitation, right? Then the third feature of preamble is secular. What is it? Secular. So secularism, one secularism which we understand of the concept which is common in Western countries is a strict separation between church and state. That is, the government and religion will not be having any interference or having any exchange between them. But in India, we developed our own form of secularism, that is principled intervention. Principled intervention. So basically here in India, the secularism which we practice is equidistant from all religions. That is, the government or the state will not be favoring any particular religion. They will be maintaining equal distance with all the religion. And of course, that is neutrality will be maintained and will not favor any particular religious community, but we will be practicing principled intervention that if required, later on we will see in fundamental rights article 25 and 26 that if required, state can go to the extent of reforming that religion if it is harming public health, law and order, and morality. So that we will see, right? Then democratic republic. So the next feature of preamble is that it declares India to be a democratic republic. What does it mean, democratic republic? That is, we will be having elected representatives. That basically the authority is in the hands of the people of India, and they will be represented in the parliament through elected representatives, right? And there will be accountable governance and popular sovereignty. Popular sovereignty means people are sovereign. People, they elect their representatives, and they will be representing the people, the wishes of the people in the parliament, right? So this is democratic republic. Democratic, that is elected representatives, and republic, there is no monarchy, no hereditary kind of thing, right? So this is democratic republic. Then other than this, the preamble promises certain things to the people of India, to the citizens of India. What these things are? Justice. The first thing which is required, or we can say that it is the foundation of a constitutional democracy, is justice. Plato has also described justice as one of the four cardinal values in a state. So this justice will be of social, economic, and political nature. Social justice, there will be no caste divides. Economic, that there will be economic equality. People will have means of living so that they can have a good livelihood. Then political, equal franchisee rights, equal voting rights, political equality. So these three justice are promised by preamble. Then liberty. Okay, liberty, freedom of thought, expression, belief, faith, and worship. So these kind of liberty will be promised to every individual, that they can think. When an individual will be able to think independently and freely, then only he or she can develop his or her personality, because thinking is from where the development starts, right? Therefore, a famous philosopher, Descartes, has said, I think, therefore I am. The human existence is nothing but the capability to think. When the mind is working, then there is prosperity. So freedom of thought, expression, they can express. If you are having certain thoughts, if you do not express it out, then what is the meaning of having thoughts? So expression, you can have your view related to the things happening in country. You can have your views related to the political matters in the country. Then belief, you can have your own belief. You can follow any religion. You can have belief related to whatever ideology you are following, then faith and worship. Okay, so you can have these liberties are basically promised by the preamble. Then equality, again it is very important. Liberty, everyone wants to be free of constraints, right? But equality is also equally important. Why? Because if some people will have all the resources and means, and someone will not be having any resources and means, then there will always be inequality. And whenever there is inequality, that will not be a sound basis of having a constitutional democracy, because that particular society is bound to face revolution time and again, and there will be no peace, no prosperity. So that is why equality is required. Equality of status and opportunity, right? Okay, liberty says that one should get according to his or her talent. Fine, we accept that. But at least opportunity should be equal. Everyone should be able to write the examination. Everyone will be able to sit into the examination of civil services, right? And based upon their capability, they will be able to clear or not, they can get into services. So this equality of opportunity and status, all are equal in front of law. So this equality of status, law cannot favor any particular person because he or she is having XYZ number into the account, bank balance, right? So the status and opportunity. Even if someone very high in the power corridors, they commit a crime, they will be subjected to the law of the land. So this is equality of status and opportunity. Fraternity, brotherhood, ensuring dignity of individual and unity. Why fraternity? Because this was heavily inspired from French Revolution, from France, Constitution of France, and also in our freedom struggle, all people, they have fought against the imperial power because of this, with common unity. So brotherhood, when we will have a sense of brotherhood among the people, then only there will be a development of the nation, right? So this is fraternity. So these are basically the key features of principle: sovereign, socialist, secular, democratic republic, and it promises justice, social, economic, political, liberty, equality, and fraternity. So after this, we will be moving to landmark judgments, how the jurisprudence related to preamble has evolved in India. So first case which was there in 1950 is the A.K. Gopalan versus State of Madras. Although this case, the matter before the Supreme Court, was not directly related to preamble, but there was certain things in the judgment, in the final judgment, which are related to preamble. So what it is, what this judgment is related to, we'll discuss. So the interpretation of Article 21. So it was, the question before the court was about the interpretation of Article 21, that is the personal liberty, which is promised through Article 21, right? In the light of preamble's commitment to justice and liberty, because preamble, we have seen that preamble promises this to the people of India: justice, socio-economic, political, and liberty, freedom of thought, expression, belief, faith, and religion, right? So when this is being promised through preamble, and Article 21 says there is personal liberty, so if a state wants to do something, wants to take certain actions to provide justice, then can it violate Article 21, personal liberty? Can individual have a personal liberty to the widest possible extent, that even if it is in contradiction to justice and liberty as mentioned in the preamble, will that be valid? So this was the question before the court. So the Supreme Court ruled that Article 21 requires only procedure established by law, not due process. Okay. So what is procedure established by law? That is, if a proper law has been passed through both the houses and got president assent and is approved and notified, then that law come into force. Just this procedure needs to be fair. The procedure needs to be followed, not the due process. The fairness, inherent fairness, was not required at that time. Later on in Maneka Gandhi judgment, we'll see that how Supreme Court has brought into the due process of law as well. But till then, it was procedure established by law, which in itself has been adopted from Japanese constitution. So this was there. So court said that even if personal liberty is curtailed for the purpose of justice, liberty, and security, that is valid, right? So here, what is the link with the preamble? That India it is of 1950. In 1947, we got independence. So for a nascent state which has recently come into existence, so this need for justice and security should be more important. We need to ensure that there is justice and security of state, and thereby limiting judicial interference. That is, judiciary would not intervene unnecessarily. So the preamble is not part of the Indian Constitution, and it is not a source of substantive power for the government. So the final thing which is related to preamble in this judgment is that preamble is not a part of the Indian Constitution, and it is not a source of substantive power for the government. Government cannot derive power from the preamble, and since it is not a part of the Indian Constitution, it can be amended. So this was basically given through this judgment, right? So here, what we need to remember is that preamble can be amended, and it is not a source of substantive power. So this was A.K. Gopalan case. Then we move to the next judgment, which is a landmark case, Berubari Union case 1960. This is the most important case related to preamble, because this was the first time that a major pronouncement related to the preamble's legal status and constitutional significance was given by the Supreme Court. For the first time, directly, the matter before the court was related to the legal status as well as the constitutional significance of preamble. What is the significance of preamble? So this was before the court. Berubari Union is basically, after the independence, certain areas in the East Pakistan. So this was to be divided. So this matter came before the court, that can we have this without constitutional amendment or not. So this was the matter. So whether the preamble constitutes an integral part of the Constitution. So this was a direct matter before the court, that preamble is an integral part of the Constitution or not. And if it is integral part, it possesses the power to limit Parliament's sovereign authority in constitutional matters. So if certain things are written in preamble, so whether that will be a constraint on the legislative powers or executive powers of the government. So this was the question before the court. Then what was the court's ruling here? The Supreme Court said that preamble is not a substantive part of the Constitution, that this is not a part of the Constitution, because in reality as well, the Constitution was drafted, and even if the objective resolution was there on 13th December 1946, after the drafting of the Constitution, the preamble was later added in front of the Constitution, right, as a four part of the Constitution. So the court said that it is not a substantive part of the Constitution and cannot impose restrictions on the Parliament's legislative sovereignty. That is, if the Parliament wants to enact a law which is in contradiction with the features of the preamble, the Parliament is free to do so. So this was basically the court's ruling here. Then the court also ruled that the legislation cannot be restrained from its function. That is, the purpose of, or the function of Parliament is to make laws. So if they are enacting any law, preamble cannot restrain their function of enacting a legislation. Preamble cannot be used to decide ambiguous part of Indian Constitution. So it is just a ceremonial thing. Basically, the crux of this judgment is that it is not a substantive part, it is only a ceremonial part. So this is Berubari Union. So finally, some significance, because another matter which was there is constitutional significance. So the court says that, okay, it is not a substantive part, it cannot be restrained to the legislative power of the Parliament, but still it has got some significance. What is the significance? It is key to open the mind of the makers, that is the constitutional framers, what was going in their mind while they were drafting the Constitution. If we want to know that, preamble is the key to that. We can get an idea of the philosophy, of the underlying philosophy, principles of the Constitution. It serves as interpretive guide without enforceable legal power. So it can help the court to interpret the features of the Constitution, the provisions of the Constitution, but it does not have legal power. You cannot get it enforced, that even if the preamble has promised you justice, social, economic, and political justice, you cannot directly approach the court asking the court to intervene in the matter for the enforcement of those things, right? So this is Berubari Union. Why it is landmark? Because what we need to remember is that the court said the preamble is not a part of the constitution, hence it can be amended freely by the parliament. Okay, next we move to another major judgment, that is Sajjan Singh versus State of Rajasthan, 1964. So the matter before the court was related to the 17th constitutional amendment. The amendment was related to the acquisition of land, right? So this person, Sajjan Singh, he approached the court related to the violation of his fundamental right of profession as given in Article 19 and earlier 19(1)(f), which was right to property, but later on it was moved to Article 301. We will see that later. But yes, so this matter reached before the court in this case, and the court said that the court basically said that preamble can be amended. Why? This was not directly the matter before the court, but the matter was that can fundamental rights be amended by the parliament? So here court said that yes, fundamental rights can be amended. Preamble could theoretically also be amended at that time, because when fundamental rights can be amended, so the preamble can also be amended. Right? So what is the significance of this judgment? This judgment basically gives us a shift in the Supreme Court's understanding related to the preamble's constitutional role and importance. Of course, the court has said that preamble is still not a part of the constitution and it can be amended, right? Because fundamental rights can be amended. Part 3, the most sacred thing in the constitution is part 3, which contains fundamental rights. So if that can be amended, of course, preamble can also be amended. But yes, court also here had a broader view related to the constitutional role and importance of preamble. That is, it is vital to our body politic. That is, the political setup in India. For that matter, the preamble is very vital, very important, because it gives us the direction what will be the constitutional setup in the country. It is not merely a ceremonial text, which was the case in previous judgment. But here the court said that it is not merely a ceremonial addition to the constitution, but it has some real job to do. That is, it is vital for our body politic, for our political setup. Then what is the purpose of preamble, constitutional purpose? It gives essential direction and purpose to the constitution, comparable to America's Declaration of Independence. So this is also the point that if someone asks from where we have adopted the preamble, so the thing is objective resolution, right? But from foreign constitution, so America's Declaration of Independence is an inspiring source from where we thought of the idea of having a preamble to our constitution as well. So constitutional purpose of having preamble is essential direction and purpose to the constitution, that what this provisions which will be followed after preamble, different parts, different schedules, right? So what different chapters of the constitution, so what is the objective of having so lengthy constitution? Basically that is being the purpose of preamble, that it communicates us the essential direction and purpose. Then legal recognition. This judgment opened the door to acknowledging the preamble's significant constitutional importance and interpretive value. That whenever there is a confusion related to any provision of the constitution, the courts can always look towards preamble for interpreting that provision, right? So the stance of the Supreme Court, the jurisprudence related to preamble has considerably improved or evolved through this judgment, Sajjan Singh versus State of Rajasthan. But still, the status or the thing related to preamble was that it can be amended at any time by the parliament. With this, we will be moving to the next major judgment, that is Golaknath versus State of Punjab, 1967. So in this judgment, again, the matter was related to some land dispute and the fundamental rights of the person whose land was to be acquired. So here, in this case, the parliament's authority to amend fundamental rights was in the question. So can parliament amend fundamental rights, or the fundamental rights are sacred and above the legislative power of the parliament? So this was in the question. So now what was the challenge here? Can parliament's powers to amend fundamental rights, testing the limit of legislative authority? So is it a limit? Parliament cannot go beyond amending the fundamental rights, or can they amend the fundamental rights? So what is the limit? Is the parliament's power to enact a legislation is without any limitation? Then what was the judgment of the Supreme Court? Supreme Court said that whenever you are amending a fundamental right or any provision of the Constitution for that matter, that amendment particularly is a law under the meaning of Article 13. So Article 13 says that if there is any law which is in contradiction to the fundamental rights under Part 3 of the Constitution, that is void. This is what Article 13 says. So for the meaning of Article 13, the law which is given there, so the amendment qualifies to be a law under the meaning of Article 13. So this is very important. So when this has been established in the judgment, so it naturally follows that the amendment for abridging the fundamental right will also be a law, and when it is violating the provisions of the Part 3 of the Constitution, it will be basically void. So basically the thing is, Parliament cannot amend fundamental rights. Parliament cannot amend fundamental rights. So this was the crux of this judgment. So when fundamental rights cannot be amended, so extrapolating this, Parliament reflects the basic philosophy of the Constitution. Any amendment conflicting with fundamental rights could be challenged. So if, let's say, Parliament is amending preamble, which promises you justice, social, economic, and political justice. If Parliament tomorrow wants to amend that thing in the preamble, so based on this judgment, it cannot be done, because it is basically the amending the basic philosophy of the Constitution. So this was A.K. Gopalan. This was Golaknath versus State of Punjab. So here the preamble's ideals were invoked to interpret the protect the inviolability of fundamental rights against legislative encroachment. So basically, when this judgment is protecting the fundamental rights and the basic philosophy, preamble automatically gets that protection. So this judgment, Golaknath versus State of Punjab, said that in this judgment, Supreme Court said that preamble cannot be amended. With this, we will be moving to the most important judgment in these categories, that is Keshwanand Bharti versus State of Kerala 1973. This is very important judgment. This is the highest ever, largest ever bench which was formed in the India, is of 13 judge bench, which is Keshwanand Bharti case. The question before the court was again the constitutional law and fundamentality redefined the preamble's legal status in the Indian jurisprudence. So basically, the question before the court was, can the Parliament abridge fundamental rights? Can they bring amendment to abridge fundamental rights? So with this, we will see that this delivered a landmark judgment, which is basically till now shaping the interpretation of different constitutional debates till now, right? Court said that preamble is integral part of the Constitution. It is integral part of the Constitution. Whether it has been added post or before, it's of no matter, but it is integral part of the Constitution. It overruled Berubari Union. We say that Parliament is not a substantive part of the Constitution and can be amended. So it overruled Berubari Union and said that it is integral and inseparable part of the Constitution with the full legal significance. That it is very important for jurisprudence in India to look towards preamble in case of any doubt, any question of interpretation related to the provisions of the Constitution. So it is having a full legal significance. Then in this judgment, the most important thing was basic structure doctrine. The court said that the philosophy, the underlying philosophy or the basic structure which defines the Part 3 or the Constitution cannot be amended by the legislative power of the Parliament. So that also includes preamble's core ideals. So basically this Keshwanand Bharti judgment said that preamble is a part of basic structure. Preamble is a part of basic structure. This is very important, which you need to remember, that preamble is part of basic structure. This was given in the basic structure doctrine, which was propounded in Keshwanand Bharti versus State of Kerala. But here the court also said that basically here the court came up with a way forward that preamble can be amended. Yes, the court is saying that preamble can be amended subject to the basic structure doctrine. That is, fundamental essence and character of the Constitution cannot be changed. If you want to bring in change into fundamental rights, okay, you can do that. If you want to bring in change into preamble, you can do that. but the fundamental essence and character of the constitution cannot be changed. So we have seen some judgments, which are the first judgment, Gopalan, preamble is not a part of the constitution and can be amended. Then we have moved to Berubari Union, preamble is not a substantive part of the constitution and can be amended. It is not a restriction on the parliament's legislative sovereignty. Then we have seen Sajjan Singh versus State of Rajasthan. Again, preamble can be amended. It can be theoretically amended at that time. Then Goloknath, it said that preamble, parliament's power to amend fundamental rights, the limit of it was in the question. So it said that preamble cannot be amended. Only this Goloknath judgment, only in the Goloknath judgment is what it was said that the preamble cannot be amended. Only in this cannot be amended. Only in this judgment. And later on, as a way forward, it was seen that in Keshwanand Bharati, the court said that, of course, there is a basic structured thing in the constitution. There is fundamental essence and underlying philosophy of the constitution, character of the constitution, which cannot be amended by the parliament. But yes, preamble can be amended unless the fundamental essence and character is being changed. Okay, so this is how the jurisprudence related to preamble has evolved in India. Next, we move forward with the recent judgments related to the preamble. So basically, recently in 2024, the matter before the Supreme Court was related to socialist and secular. These two words were added by 42nd Constitutional Amendment 1976. So whether this addition of socialist and secular in the preamble is valid or not, the court said that yes, it is perfectly valid, because it is basically describing what the constitution or different provisions of the constitution aims to achieve. Okay, then socialist interpretation, the court said that the socialist here is not the ideology socialism. The purpose of the socialism in India is having social justice, having a welfare state, and is not related to the adherence to any rigid economic ideology or system. So basically, by socialist, we are trying to achieve a welfare state and social justice rather than any economic ideology like capitalism or communism. Then secular definition, court said that again, secularism has equal respect for all religion, and the state cannot discriminate between religion and people based on their religious belief. Okay, so this is also perfectly fine, the court said. Then court said that our constitution is a living document. Time and again, we have brought into different amendments to make it a living constitution, right? So preamble is also a living document, and when any amendment is made in the preamble, that is not any invalid thing. It can be done. So that is why 42nd Amendment has brought socialist and secular, and that was upheld by the court. That there is no issue with this amendment. With this, we move forward to the significance of preamble. What is the significance of preamble? It is the soul of India, constitutional soul of India. That what the constitution, this bulky constitution, wants to achieve. What is the underlying basis, underlying philosophy, underlying principles of the constitution? That soul is preamble. It gives a constitutional identity, that is, embodies India's fundamental constitutional character and the aspirations for justice and equality. That is, we want to achieve justice and equality. This is what the constitution wants, preamble wants to communicate, right? Then legal evolution. Progressive judicial recognition has transformed it from mere introduction to enforceable constitutional provisions. We have seen that it is no more a ceremonial addition to the constitution. It is having a real legal basis, that it can be used and it has to be used by the court while interpreting different provisions of the constitution. So it has a firm legal basis. Then democratic beacon. The preamble itself says that we want to achieve justice, liberty, equality, fraternity, democratic republic country, right? So it is a democratic beacon. It says that India, future India, will be of so and so nature. Then interpretive guide. Okay, the purpose which Parliament serves for the court is to help them in interpreting different provisions of the Constitution. And then social inspiration, again, inspire social movements and democratic struggles for justice and equality, because the preamble itself says socialist, secular, democratic republic. So these words, they inspire people, right? So this is social inspiration. So preamble is the soul of the constitution, reflecting hopes, aspiration, and values of the people of India in their quest for just and equitable society. So this is what is the preamble of the constitution. So we have gone through the features, the significance, landmark judgments, the definition, purpose, and finally the preamble as a soul of the constitution of India. So thank you all.